Hello, everyone. Welcome to Save News TV. I am your host, A.Z. Hubbard, and I'd like to thank you for inviting us into your homes today. Well, as usual, we have news that is going on, and as you know, we have been following the TD Jakes versus Duane Youngblood case. We want to say over here, we really pretty much stick to the facts. We read the case, we do give commentary, but we are like Switzerland, we are neutral. We give an unbiased commentary, weighing the sides of dif- both parties, both TD Jakes and Duane Youngblood. Anyway, with that said, this is a pretty long case, and this anti-SLAPP, it has a lot of exhibits and everything, so we will not be reading all of that. It is like 167 pages. Oh, that is crazy work. We're not going through that. We will highlight the main part of the document, the case, and we will show some exhibits. Now, if you want to see all of the exhibits, you can join, you can be a member because it would be in the membership section because these cases cost money for me to get. And so I'm not, I can't put it out there freely to everyone. So you can, if you're a member, you can view all the court documents and everything at a fraction of the price that it costs me. But anyway, with that said, I am excited to get to reading and we will make some commentary. So make sure you like, share, and subscribe. Like, share, and subscribe. And we will get into this case right now. All righty, everybody, let's get to the meat of the matter. Let me enlarge this somewhat. Zoom. Okay, so here we are. This is the United States District Court for the Western District of Pennsylvania. Thomas Dexter Jakes is the plaintiff and against Duane Youngblood. 2. Plaintiff Thomas Dexter Jakes and his attorney of record. Please take notice that defendant Duane Youngblood, by and through his counsel, T.A. Blackburn Law, PLCC, hereby moves this court to dismiss plaintiff's complaint pursuant to Pennsylvania anti-SLAPP statute, codified at 42 PACS 8340.11 Esquire. This motion is based on the following grounds. 1. Protected public expression. Defendant statements are protected public expression addressing matters of significant public concerns, including systematic abuse and institutional accountability within religious organizations, and are thereby safeguarded by the Pennsylvania Anti-SLAPP statute and the First Amendment of the United States Constitution. 2. Failure to state a prima facie case. Plaintiff's claims of defamation per se and civil conspiracy failed to meet the requisite legal status under Pennsylvania law, as plaintiff has not demonstrated falsity, actual malice, or actionable harm. 3. Public policy. Allowing defendant's claim to proceed would violate public policy, as it would chill constitutionally protected speech on matters of public concern and contradict the legislative intent of Pennsylvania's anti-SLAPP statute. 4. Entitlement of attorney fees. As a prevailing party under the anti-SLAPP statute, defendant is entitled to an award of attorney fees, costs, and litigation expenses incurred in defending against this baseless and retaliatory lawsuit. This motion is supported by accompanying memorandum of law, the declaration of Tyrone A. Blackburn, Esquire, and exhibits attached here too. And whereas a sworn declaration from defendant Youngblood, defendant respectfully requests that the court grant the motion to dismiss plaintiff's complaint with prejudice and award attorney fees and costs pursuant to 42 PA, the thing. Okay, so right here on number 4, pretty much is with an anti-SLAPP case, they have to pay the fees. They would if the judge dismiss the case, then TD Jakes would have to pay the attorney fees. And another point I wanted to make in section 4, uh basically, is that those 4 steps are their reasoning for their desire to dismiss. And so let's move on and we'll discuss a little bit further. The next portion of this case is the proposed order granting defendant special motion to dismiss. Now, pretty much what this is that when you file an order, you need to put a proposed order in for the judge to sign. Generally, some people are, which I thought for many years until I had found out for myself, is that the judge does not write these orders. When they sign on rulings, it's sometimes it's rare. I won't say it's always rare, depending on the type of ruling. Generally, the prevailing attorney or the prevailing plaintiff moving party is the ones their attorneys will write that order, and the judge will sign that order. So that is how that works. Sometimes the judge will write their own orders if one is not supplied, and if they want to expound upon the definition on why they have signed that. Okay, so this is the order that Blackburn wants the judge to sign on behalf of Youngblood. Okay. Proposed order granting defendant special motion to dismiss pursuant to Pennsylvania. Upon consideration of defendant Duane Youngblood's special motion to dismiss pursuant to Pennsylvania anti-SLAPP of the law is supported hereby in all related submissions and arguments presented to this court, and for good cause, it is hereby ordered that 1, defendant's motion is granted. 2, plaintiff's case is dismissed with prejudice in its entirety. 3, pursuant to defendant is awarded attorney fees, court costs, and litigation expenses. Defendant counsel is directed to submit a detailed accounting of fees and costs to the court within 14 days of the order. 4, the clerk of the court is directed to close this case. Now, again, remember, this is what Youngblood desires, his attorney. This is not an order from the judge. This is the proposed order. Nothing has been dismissed. Judge Stigman has not ruled on this case, this anti-SLAPP motion. So please keep that in mind. There might be some people that will read this and run with, the case has been dismissed. No, at this point, the case has not been dismissed. All right. So it said here's so order. You don't see a date up here and you don't see a signature by the judge. So again, remember, the case has not been dismissed as of this recording. Okay. And this is what they go through as far as pursuant of the anti-SLAPP statute. Now, like I said, this is a long thing. So this is what is included in this, along with other things. We're going to not go through that. We're going to go through the part that is important to us. Okay, introduction. It is the court's This court is tasked with addressing one of the most egregious attempts to pervert the judicial process for personal gain. Plaintiff Thomas Dexter T.D. Jakes had a self-proclaimed spiritual leader, reverend by millions, has weaponized this lawsuit not to seek justice, but to muzzle the voice of truth. Okay, I want to stop right here before I really get into reading this and make this statement. Is that when, as you all know, you people that follow Save News, and when we've covered cases like this, you already know that whatever is put in a lawsuit, it is just their side of the story. It's not factual until a ruling comes down. So this is what the um defendant Youngblood is claiming, just like when TD Jakes was claiming certain things when he filed his lawsuit. That's their truth. That is not the judge's truth, what the judge has ruled on, or if there is a jury, that the jury has decided which is the truth. So as I'm reading this, please keep in mind that what I'm reading is not factual until proven. And at this point, at this juncture, it is not proven. They are putting their case to the judge, to the court, in order to have a desired outcome. Okay. So, with that said, I'll continue reading. His hypocrisy is staggering. Standing in the pulpit on Sundays to preach virtue while allegedly engaging in depraved acts, betraying the principles he claims to uphold. As scripture warns, beware of prophets, false prophets, who come to you in sheep's clothing, but inwardly they are ravenous wolves. Matthew 7:15. Plaintiff epitomized this warning, using his platform to project an image of righteousness while allegedly abusing his power to satisfy his closest closeted homosexual desires. Again, these are allegations. And TD Jakes has denied these things. Okay, just like Youngblood, when we read the initial case, Youngblood has denied TD Jakes allegations. So I'm gonna stop saying that and I'm gonna get back into the reading because I got a lot to read. All right. Defendant Duane Youngblood is a survivor of clergy abuse and an advocate for transparency. Stands accused of defamation and other baseless claims for daring to speak his truth. However, the defendant's narrative is not one of vengeance, it is one of redemption and accountability. By no means is defendant a patron saint. He has admittedly done things in his past that he is ashamed of. And after he has served his time, he has focused on publicly atoning for his actions. The defendant is trying to shed light on systematic abuses within religious institutions. His statements, grounded in lived experience and supported by collaborating affidavit testimony, are a very type of protected speech Pennsylvania anti-SLAPP statute seeks to preserve. This motion seeks to dismiss the plaintiff's retaliatory complaint and highlight the gross misuse of power by a man who has consistently avoided accountability. The Bible rebukes such duplicity. You shall not misuse the name of the Lord your God, for the Lord will not hold anyone guiltless who misuses his name. Exodus 20:17. Plaintiff's actions represent and affront of this commandment, exploiting the sanctity of faith to shield his misconduct. By granting this motion, this court will affirm the principles of free speech and justice while ensuring that those who abuse their positions are held accountable. Factual background. As a as the leader of the Potter's House in Dallas, Texas, the megachurch with an international following, plaintiffs wield significant influence over millions of congregants and the broader Christian community. Despite this public image of moral authority, serious allegations has emerged accusing him of engaging in sexual exploitative behavior and abusing his position of power. Defendant Duane Youngblood is a survivor of childhood SA and a former pastor who has dedicated his life to raising awareness about systematic abuse within religious institutions. Defendants disclose are deeply personal, recounting his experience of grooming and abuse by clergy members, including plaintiffs. These statements are not recent fabrications, but part of a consistent narrative shared over years, both privately and publicly. The defendant's experiences have left lasting scars. Diagnosed with post traumatic stress disorder, PTSD, anxiety disorder, and severe depression. Defendant has spent years in therapy addressing the impact of abuse he endured. Excuse me. Okay, I'm gonna have to be drinking my tea as we go through this, my Jamaica tea. His public statements are part of a broader therapeutic journey rooted in the desire to heal and prevent others from suffering similar harm. Through this process, the defendant has taken responsibilities for his past missteps and has become an advocate for survivors, exposing the pervasive issue of clergy abuse and calling for systematic reform. Multiple sworn affidavits collaborate defendant's account. Witnesses such as Jeffrey S. Gray and Richard Edwin Youngblood have provided detailed testimonies recounting defendants' disclosure about plaintiff. Jeffrey S. Gray attested to a specific incident in which plaintiff allegedly made unwelcomed advances towards defendant following the church service in Pittsburgh, Pennsylvania. See Defendant Exhibit A. Richard Edwin Youngblood confirmed that defendant consistently described plaintiff's attempts to groom him, including an alleged financial proposal contingent upon S favors. Exhibit D, Exhibit B, Blackburn Declaration Exhibit B. In addition to Jeffrey S. Gray and Richard Edwin Youngblood, the defendants had affidavits from David B. Spaulding, LaShawn Youngblood, Jose Joshua Munez, and Landon Claiborne, and that's going to be exhibits C through F. Again, like I stated earlier, those exhibits will be in the members only section. Okay. Public scrutiny of the defendant's behavior has intensified in recent years, fueled by viral social media content and investigative reporting. Numerous reports have linked plaintiff to inappropriate relationships with with young men, in particularly in S charge gatherings hosted by Sean Diddy Combs. Ooh, let me give it some water. Okay, I'm just gonna tell you all, skimmed over some of this lawsuit, and it gets a little spicy. And if those that are aware of Sean Puffy Combs, Puff Daddy, P Diddy um, situation, if you followed it any, you know that there is association as far as photos and allegations regarding the questionable relationship between TD Jakes, Bishop TD Jakes, and Puffy. I don't know. I wasn't there. I just know what is out in the streets, and some of it I don't know. But anyway, they're going to tell us what some of what Sean Puffy Combs did. Okay. Sean Combs is currently under federal indictment for RICO S trafficking, prostitution, etc. One of Mr. Combs' male S workers has come forward and named Bishop Jakes as a participant in Diddy's quote unquote freak off parties. Okay, I gotta take another sip of tea. Okay. Allegations includes plaintiff's alleged grooming of male mentees and his role in covering up misconduct within religious organizations. See Blackburn Exhibit G. More about Jake's gay accusations plus PDF activities lands online. And this is Exhibit H. Jake's, if everything was true, all I got to do is repent. I'm telling you all, the exhibits that's going to be in the members only section is, you know, I'll skim through it real fast on some of these, but I'm not gonna go over all these exhibits because there are a lot. Okay. But we were gonna read through this case. Defendant has alleged that the plaintiff and his associates have engaged in retaliatory conduct to silence him. Not only has the plaintiff filed a baseless lawsuit, but defendant has also reported receiving threats from individuals associated with plaintiff, including his son. See Exhibit I. These actions have exacerbated defendant's PTSD and heightened his sense of vulnerability, reinforcing the psychological toll of his past trauma with plaintiff. Exhibit J. Despite the mounting evidence and public discourse, plaintiff continues to portray himself as a moral and spiritual leader, using his platform to denounce those who seek accountability. His public sermon dismissing the allegation as quote unquote lies starkly contrasts the biblical principle he claims to uphold. As Proverbs 28:13 declares, whoever conceals their sin does not prosper, but the one who confesses and renounces them find mercy. The plaintiff's refusal to address the allegations transparently underscores the hypocrisy of his position. Exhibit K. Far from malicious, the defendant's statements are rooted in lived experiences and serve as a critical public purpose. Excuse me. By sharing his story, the defendant contributes to a broader conversation about systematic abuse, the failures of institutions to protect the vulnerable, and the urgent need for accountability. These disclosures align with Pennsylvania anti-SLAPP law statute's goal of preventing free expression from being matters of public concern. Legal statute. Under Pennsylvania's newly enacted anti-SLAPP law, a special motion to dismiss may be filed against lawsuits targeting protected public expression. The statute is modeled on similar laws in other jurisdictions and explicitly aimed to curb litigation intended to silence speech on matters of public concern. Key provisions of the anti-SLAPP statute. Let's see how much this is. Okay. Okay. Yeah, we're still going to read this because, some people might think this is boring, but, those that follow Save News, you all know that you like that information. So let's read this. And then the case, but you need to we all need to understand what anti-SLAPP really means. Okay. Protected public expression. The statute defines protected public expression as any communication related to matters of public concern, including one, speech made in legislative, executive, judicial, or administrative proceedings. Two, communications under review in such proceedings. Three, speech on issues of public importance, encompassing the rights of the freedoms of speech, press, assembly, and petition, and guaranteed by the First Amendment of the United States Constitution, Article 1, Section 7 of the Pennsylvania Constitution. Grant of immunity. A party is immune from civil liability if the actions arise from protected free expression and the plaintiff fails to establish a prima facie case for their claims. Special motion to dismiss. Defendants may file a motion within 60 days of being served with the complaint. Upon filing, all other proceedings, including discovery, are stayed unless the court permits limited discovery necessary to address the motion. Burden shifting. Once the defendant demonstrates that the action arises from protected expression, the burden shifts to the plaintiff to establish a primary of prevailing of merits to his claim and rewards of prevailing parties. If the defendant prevails, the court must award attorney fees, costs, and litigations. Conversely, if the court finds the motion frivolous, the plaintiff may recover their costs. Okay, this is important here. The burden shifting, we'll go down to the other. Because now the burden of proof that, if this is proved, then instead of the burden of proof being on the defendant, like it says, it shifts to the plaintiff. Okay. So public concern. The defendant's statements about the plaintiff's misconduct highlight systematic abuse, institutional accountability, and the misuse of power by religious leaders. Courts consistently recognize such topics as matter of public concern. In Pennsylvania newspaper versus Helps, the Supreme Court held that speech addressing public issues occupies the highest rung of the First Amendment protections. Here, defendants' disclosures about plaintiffs' grooming and exploitation directly contribute to the public discourse on systematic abuse within religious institutions. The defendants' allegations were the latest in a chorus of allegations of SA, closeted homosexuality, and grooming directed at plaintiff Jakes. Ironically, plaintiff Jakes has only opted to sue defendant, but has purportedly paid off several men who raised the same and or similar claims as defendant. Oh, okay. The allegations that plaintiff participated in S parties and engaged in grooming behavior have been widely reported in public forums, including TikTok and investigative media. The defendant's statements, such as quote unquote, Bishop Jakes groomed me, and quote unquote, he used his position as a pastor to manipulate and exploit me, are directly tied to these public conversations and contribute to broader societal awareness. Chilling effect of free speech. Allowing plaintiffs' claim to proceed would set a dangerous precedent, discouraging survivors and advocates from speaking out against powerful figures. In Pennsylvania General Assembly specifically noted that the statute would be broadly construed to protect such speech. In New York Times Company versus Sullivan, the Supreme Court recognized that imposing liability for defamation on public figures, officials, without proof of actual malice would lead to self censorship, chilling free speech. Similarly, in the current case, the defendant's statements address public figures and matters of significant public concern and litigation against such risks, speech risks, suppressing essential public discourse. The court in Sullivan emphasized the First Amendment protests robust debate on matters of public importance. Even if such debate matters, harsh criticisms of errors to avoid silencing individuals who seek to expose wrongdoing. Bishop Jakes, okay, Bishop Jakes is a self proclaimed, quote unquote, world renowned spiritual leader, global philanthropist, author, film, and music producer. In Gertz 418 U.S. at 315, the Supreme Court identified two distinct categories of public figure. The first is an all purpose public figure who achieve such pervasive fame or notoriety that he becomes a public figure for the purpose and in all contexts. ID at 351. The second is a limited public figure who voluntarily injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. That limited range of issues is identified by looking to the nature and extent of the individual's participation in a particular controversy, giving rise to the defamation. Lumbris versus Uncommon Prods. Okay. If a plaintiff has attempted to influence the resolution of that controversy, the plaintiff is considered a limited public figure and bears the heavy and often unsurmountable burden of proving actual malice. The controversy at issue must predate the alleged allegations. Here, the court can take judicial notice that the plaintiff is an all purpose public figure, as that term is defined by Gertz, as the plaintiff self identified as such in paragraph 4 of his baseless complaint. As a result of the self proclamation, the plaintiff is voluntarily adopted the burden of pleading actual malice under New York Times Company versus Sullivan. Okay. The requirements that the plaintiff be able to show actual malice by clear and convincing evidence is initially a matter of law. Tucker. The question whether the evidence in the record in a defamation case is sufficient to support finding of actual malice is the question of law. This rule is premised on the unique character of the interests protected by the actual malice standard. Hart Hanks Communications Inc. versus Culligan. More fundamentally, the rule is derived from the recognition that judges, as explorers of the Constitution, must independently decide whether the evidence in record is sufficient to cross the constitutional threshold that bars the entry of any judgment that is not supported by clear and convincing proof of actual malice. As to what constitutes actual malice, the federal high court has held actual malice at the minimum that statements were made with reckless disregard of the truth. That is, the defendant must have made false publication with a high degree of awareness of probable falsity, or have entertained serious doubts as to the truth of his publication. Also, the standard is subjective. One, there must be sufficient evidence to permit the conclusion that the defendant actually had a degree of awareness, probable cause. Here, this billing exercise, poorly disguised as a defamation complaint, focuses on the compulsory civil conspiracy and the defendant's criminal past, as opposed to denying any of the aspects of the defendant's 10-minute story aside from the claims of grooming and SA. Plaintiffs have plaintiff have failed miserably to show that defendant had a high degree of awareness of probable falsity, and that he entertained serious doubts as to the truth of his publications. Plaintiff failed to meet the heightened pleading standard because defendant was not lying. Plaintiff knows that the defendant confronted him about his actions. Plaintiff knows that the defendant has been crying out for help to the church elders, telling his account of the plaintiff's assault to anyone who would listen for nearly 4 decades. The evidence by the defendant's sworn affidavit witness statements, his story has remained the same for nearly 40 years. Okay, everybody. All right, we're going to take a 2-minute break. I'm going to give you all a 2-minute break right here. I'm going to play a little video so you all can get you a little break in here, and then we will be right back after this. Will be a 2-minute little notice here so you can go get you some then to drink or to eat, and then we're gonna come right back on it.
I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify. I am spreading the faith I hold so dear, for every tear he's ever near. Choirs rise on Sunday morn, his love we adorn. Each melody a testimony, hearts reborn. In every verse a whispered prayer beyond compare, to lift the hearts of those in dark despair. We testify with every note we sing, in harmony let freedom's bell ring. Rejoice and lift your voice, let the the sound of praise deploy. Marching to his beat we go. Face the seed we're here to sow. A standing strong through trials. Love's chapter will compile. A beacon shining, grace defining across the mile. In our stories, his glory shines a light divine. Through the gospel groove, his truth we move, lives alive. Each Sunday pew, a vessel lined with grace anew. Souls intertwined, the word defined, it shines on through. Lifting high the cross we bear, in silence share. Hey, hey. The hymn we breathe, in him believe, it's love we declare. We're saved by grace in this whole levered place. Voice is strong in this soulful song we embrace.
Okay, everybody, we back. Let me know if you all enjoy those little breaks in between, because sometimes when the video gets long and a lot of reading and not that much commentary, it can get a little long. So put in the comments chat and let me know if you like those. If not, I can take them out. Either way, um, we get into the back to the reading of the read. Okay. TD Jakes is defamation proof. Public discourse about plaintiffs' alleged misconduct is widespread and well known. Social media platforms and investigative reports have brought to light allegations of grooming, SA, and exploitation involving plaintiffs, with specific claims alleging, remember these are allegations, alleging one, plaintiff's participation in S parties hosted by Sean Diddy Combs, as reported by multiple sources. Exhibit I, Bishop T.D. Jakes and longtime friend accused of SA. See Exhibit M, Kenneth Copeland, T.D. Jakes, and Rick Warren are being accused of SA. LGBTQ Nation. Two, text messages allegedly sent by plaintiff to a male mentee containing flirtatious and inappropriate content. Exhibit N, text messages of Bishop T.D. Jakes surfaces of him flirting with man. And three, allegations by plaintiff's former mentee Manasseh Jordan, who claimed that plaintiff groomed and SA'd him during his youth. Um, Exhibit O, alleged victims of Bishop T.D. Jakes planning legal action. So anyone that's in the Christian community um, might know who Manasseh Jordan is. He is the son of Bishop Prophet Jordan, and Prophet Jordan is a very well known prophet. So that is his son who has made those. So just for a point of reference as to who also made those allegations. Statements from alleged victims of plaintiffs include, and we just read over that, and again, this would be in the membership section. These are just a handful of statements made by individuals who have come forward to share their victimization by the plaintiff. Despite these allegations, the plaintiff continues to portray himself as a moral authority, preaching to millions while allegedly living a double life. It is clear from these articles that Plaintiff Jakes has been the topic of discussion in public for several years prior to the interview with Larry Reed on 10/28/24. Whoever walks with the wise becomes wise, but a companion of fools will suffer harm. Proverbs 13:20. A man is known by the company he keeps, and is not surprisingly, plaintiff keeps company with indicted Rico S. trafficker Sean Combs and alleged SA members of the clergy, Eddie Long, Kenneth Copeland, and Rick Warren. Woo! Okay, remember these are just the opinions of what's that, but it is definitely juicy as far as telling stuff, but we stick to the facts. We read this again. Bishop Jakes has denied these claims, and these are claims by Youngblood, and he is trying to prove his case by bringing this action. Okay, for instance, Bishop Eddie Long, a close compatriot of plaintiff, was accused of coercing young men for favors under the guise of spiritual mentorship. Although Long denied the allegations, he settled multiple lawsuits filed by his accusers. During the time these accusations came out, plaintiff stated in a CNN interview on August 2013, that what Bishop Long was going through concerning the allegations was a quote unquote tragedy. He said, he then said that he tried to quote unquote counsel and comfort Bishop Long. Other prominent figures such as Kenneth Copeland and Rick Warren have also faced accusations of misconduct, highlighting systematic issues within religious institutions. And that's going to be Exhibit M. Defendants' public statements concerning his childhood assaults committed by members of the clergy contribute to a broader conversation. The defendant's public statements contribute to a broader conversation about the systematic failures within religious institutions to protect vulnerable individuals. His disclosures are vital to ongoing efforts to protect future congregants from future harm. The Catholic Church similarly has faced a deluge of SA claims worldwide. Thousands of priests have been accused of SA and minors, leading to multi-billion-dollar settlements and calls for systematic reform within the church. Reports indicate a long history of institutional cover up where clergy members were relocated rather than held accountable for their actions. This pattern underscores the broader systematic issues within religious institutions that prioritize self preservation over accountability and justice for victims. Argument. Defendant statements are protected public expression. Defendant statements about plaintiff, a self proclaimed globally prominent religious leader and public figure, address matters of significant public interest, including systematic abuse, institutional accountability, and the misuse of power within faith based organizations. As a public figure, plaintiff must meet a heightened standard to claim defamation, as is established in New York Times versus Sullivan. This heightened standard exists to ensure that public discourse remains robust, uninhibited, especially when addressing issues of social concern. A. The plaintiff's public figure status is plaintiff T.D. Jakes is undeniably a public figure. Implications of a public figure status. As a public figure, plaintiff cannot claim defamation per se without proving actual malice. That is, that defendant knowingly published false information or acted with reckless disregard for the truth. This standard, outlined by the New York Times Company versus Sullivan, serves to protect speech on matters of public concern. even if the speech is critical or unfavorable. Courts have consistently emphasized the importance of safeguarding discussions about public figures to prevent a chilling effect of free expression. Hustler Magazine versus Falwell. The importance to the state and to society of such discussions is so vast, and the advantages derived are so great that they more than counterbalance the inconvenience of a private person whose conduct may be involved and occasionally injury to the reputations of individuals must be held must be yield to public welfare. Although at times such injury may be great, the public benefit for publicity is so great, and the chance of injury to private character so small that such discussions must be privileged. New York Times versus Sullivan Exhibit P. Okay, so they bringing out these exhibits. Defendant's statements made during the interview on Larry Reed Live address issues of systematic abuse within religious institutions and included personal accounts of misconduct by plaintiff visited upon defendant. These statements contribute to a broader societal dialogue and are firmly protected under Pennsylvania anti-SLAPP statute and the First Amendment. The defendant's statements were made during a widely respected interview on Larry Reed Live, a premier YouTube platform that champions community advocacy and reform, particularly within the Black church and the broader African diaspora. Hosted by Mr. Larry Reed, an artist, clergyman, autistic entrepreneur. The platform provides survivors of clergy abuse a safe space to voice their experiences and raise awareness about systematic issues, including SA and institutional corruption. Defendant statements about plaintiff, a globally prominent religious leader, address matters of significant public interest, including systematic abuse, institutional accountability, and the misuse of power within the faith based organization. Under Pennsylvania's anti-SLAPP statute, such speech is safeguarded when it pertains to public certains and contributes to societal discourse. Exhibit Q. Matters of public concern. Speech involving public figures and institutions addressing societal or systematic issues is accorded the highest level of First Amendment protection. The Supreme Court in Philadelphia Newspaper Inc. versus Helps emphasized that speech on matters of public concern lies at the heart of free expression and must be safeguarded to ensure robust debate. Exhibit R. A public figure plaintiff must show the falsity of the statements at the issue of in order to prevail in a suit of defamation. Garrison versus Louisiana. Reading New York Times. Okay. For the proposition that public official is allowed the civil defamation remedy only if he establishes that the utterance was false. See Herbert versus Lando. The plaintiff must focus on the editorial process and prove a false publication attended by some degree of culpability. Philadelphia Newspaper versus Helps. Defendant's disclosure about alleged misconduct by plaintiff falls squarely within the category. as they expose abuses of power within the global influential institution by self proclaimed globally influential clergymen. In a case presenting a configuration of speech, a plaintiff like the one we face here, and where the scales are in such an uncertain balance, we believe the Constitution requires us to tip them in favor of the protecting free speech to ensure that that true speech on matters of public concern is not deterred. We hold the common law presumption that defamatory speech is false cannot stand when the plaintiffs seek damages for speech of public concern. Philadelphia newspaper versus Helps. The defendant's statements contribute to a critical and ongoing dialogue about institutional reform and accountability. Dismissing this lawsuit would reinforce the legislative intent behind the anti-SLAPP statute, ensuring that the judicial system is not misused to suppress speech on matters of profound public concern. Pennsylvania headed the national practice of holding clergymen accountable for depravity. In Pennsylvania, a public policy underscores the importance of investigating and eradicating S abuse within clergy. This commitment was exemplified by the 2018 Pennsylvania Grand Jury Report, which details decades of systematic abuse and cover ups within the Catholic Church, affecting thousands of victims across multiple dioceses. Pennsylvania's former Attorney General and current Governor Josh Shapiro described the reports as the largest, most comprehensive report into child SA within the Catholic Church ever produced in the United States. Pennsylvania has since enacted policies and pursued investigations to hold religious institutions accountable and encourage transparency to protect vulnerable population. You know, I got to get my tea again, y'all. I'm doing a lot of reading here. Thank you. The defendant's statements contribute to this critical discourse by adding his personal testimony of clergy abuse to the chorus of other survivors of clergy abuse during Pennsylvania. In Pennsylvania, defendants' advocacy aims to address the failure of Black religious institutions to protect individuals from predatory clergy and expose systematic issues that predicate abuse. Platforms like Larry Reed Live serve as a safe space for survivors of clergy abuse to amplify these discussions, ensuring that survivors and advocates can voice their concerns while fostering accountability and reform. A year before defendant's interview, plaintiff former mentee Manasseh Jordan used Larry Reed Live to come forward and share his experience being groomed and SA'd by plaintiff. Speech involving public figures and institutions addressing societal or systematic issues is accorded the highest level of the First Amendment protection. The Supreme Court in Philadelphia newspaper versus Helps emphasized that speech on matters of public concern lies at the heart of free expression and must be safeguarded to ensure robust debate. Defendant's disclosure about misconduct by plaintiff, which was visited upon him, falls squarely within this category. As we expose potential abuses of power within a global influential institution, Additionally, the defendant's statement during Larry Reed's live interview were part of a broad 2-hour discussion centered on accountability, signs of grooming behavior, and the systematic failure of church leaders to address issues of depravity within the clergy. Only approximately 10 minutes of this dialogue pertains to plaintiffs specifically, highlighting how defendant's speech was not targeted, but rather part of a critical conversation aimed at meaningful reform within the faith based organizations. In his disclosures, defendant identified plaintiff as one of several male figures who allegedly SA'd him during his childhood. These statements were made in context of raising awareness about a pervasive nature of clergy abuse and long-term impact of such actions on survivors. The defendants allegations contribute to the necessary and urgent discussion about institutional accountability and the need for systematic change. Speech involving public figures and institutions addressing societal and systematic issues is acc- accorded the highest level of First Amendment protection. The Supreme Court in Philadelphia Newspaper Inc. versus HEP. Here, plaintiff, here platforms like Larry Reed Live play a critical role in fostering this necessary dialogue in giving the survivors and advocating for meaningful reform. Okay, everybody, we are definitely on it. Anti-SLAPP protections. Pennsylvania anti-SLAPP statute is designed to protect individuals from lawsuits aimed at silencing constitutional protected speech. The statute recognizes the litigation is often weaponized to intimidate or financially burden defendants who engage in public discourse. In this case, defendant statements are squarely protected under the statute, and the plaintiff's claims failed to meet the required legal standards. The statute mandates that its provisions be broadly construed to encourage participation in public discourse on matters of significant societal importance. Defendant statements on Larry Reed Live pertain to allegations of misconduct by plaintiff, a globally recognized religious leader, and systematic issues within the church. These are quintessential matters of public concern. Pennsylvania's statute mirrors the principles and similar laws in states like California, Texas, which courts have upheld as critical to preserving the free expression of public platforms. Burden shifting to plaintiff. Once the defendant demonstrates that the claims arise from protected public expression, the burden shifts to plaintiff to establish a prima facie case for each element of their claims. Plaintiff must present admissible evidence to prove that the defendant's statements are false and made with actual malice. However, plaintiffs have failed to provide credible evidence to meet this burden, relying instead on speculative assertions, immunity, and judgment as a matter of law. The statute provides immunity if the plaintiff cannot establish a prima facie case or if the court determines that there is no genuine issue of material fact entitling defendant to judgment as a matter of law. Here, defendant's statements are supported by affidavits, public reports, and cooperating testimony. The plaintiff's inability to demonstrate actual malice or falsely renders their claims legally insufficient. Stay of proceedings and costs. Under 8340.16, filing a special motion to dismiss stays all proceedings, including discovery, unless limited discovery is necessary to determine the motion's outcome. The court has denied plaintiff's motion for expedited discovery. The provision prevents plaintiff from using the litigation process as a means of harassment. Prevailing defendants are entitled to attorney fees, court costs, and litigation expenses. Defendant respectfully seeks such relief as plaintiff claims are baseless and serve only to to burden the judicial system. Well, everybody, we have a playlist of all of the cases and the readings. So we did go over the expedited discovery. Please visit our playlist and you will be able to find it there. Okay. Plaintiffs cannot establish a prima facie case. Defamation per se claims fail. Under Pennsylvania law, to prevail in a defamation action, plaintiff has the burden of proving one, the defamatory character of the communication, two, its publication by the defendant, three, its application to the plaintiff, and four, an understanding by the reader or listener of its defamatory meaning. Five, an understanding by the reader or listener of the intent of the defendant that the statements refers to the plaintiff. Six, special harm resulting to the plaintiff from the publication. Seven, abuse of continually privileged occasion. Truth as a complete defense. Pennsylvania law unequivocally recognized truth as an absolute defense to defamation. Tucker versus Philadelphia Daily News. Defendant statements are corroborated by sworn affidavits, victim testimony, and publicly available reports that align with defendants' disclosures of systematic abuse within religious institutions. Plaintiff cannot meet the burden of proving falsity or demonstrating that the defendant's statements lack substantial truth. Actual malice not demonstrated. As a public figure, plaintiff must establish a clear and convincing evidence that defendant acted with actual malice, that is, with knowledge of falsity or reckless disregard to the truth. The defendant's statements, based on personal experiences and corroborated accounts, were made in good faith with the intent to expose the systematic abuse. The plaintiff has offered no evidence to support the claim as actual malice, no evidence of reputational harm. To sustain a defamation per se, the plaintiff must demonstrate concrete harm to his reputation. Speculative assertions of harm are insufficient. Plaintiff has failed to present admissible evidence of reputable damage directly resulting from defendant's statements. Within such evidence, the claim cannot stand. Civil conspiracy claim fails. To state a claim for civil conspiracy, a plaintiff must allege a combination of two or more persons to do a criminal act or to do a lawful act by unlawful means or an unlawful purpose. The plaintiff must make specific factual allegations of combination, agreement, or understanding among all or between any of the defendants to plot, plan, conspire to carry out the alleged chain of events without more parallel conduct does not suggest conspiracy. The allegations of conspiracy are must be grounded firmly in facts. They cannot be consultatory, nor can they hinge on bare speculations and foundationless speculations. Those was a tongue twister. Woo! Y'all be patient with my sister. Okay, where am I at? You state cases affirming dismissal of conspiracy claims based on mere speculation and speculation. No evidence of unlawful agreement. Civil conspiracy under Pennsylvania law requires proof of an agreement to perform an unlawful act or achieve a lawful result through unlawful means and overt actions in furtherance of that agreement. Plaintiff's allegations of coordination between defendant and others are speculative at best and unsupported by any credible evidence of the agreement to harm plaintiff. Lack of actionable underlying tort. Civil conspiracy is a derivative claim that requires an actionable underlying tort. Here, plaintiff's defamation claim fails to as the matter of law, rendering the conspiracy claim legally unsustainable. Without an actionable tort, the civil conspiracy claim must be dismissed. Failure to demonstrate legal harm. The plaintiff has not shown actual legal harm resulting from any alleged conspiracy. Assertions of generalized injury or reputational harm fail to meet the standard to sustain a civil conspiracy claim. Moreover, Pennsylvania law precludes recovery where the underlying tort is unsubstantiated. Civil rights conspiracy claim provides a remedy against private conspiracies or conspiracies by state actors. It creates a private right of action for persons injured by a conspiracy form for the purposes of depriving, either directly or indirectly, any person or class of persons of the equal protection laws and of equal privileges and immunities under the law. To prevail on a conspiracy claim under 1983, the plaintiff must prove that persons acting under color of state law reached an understanding to deprive him or her constitutional rights. More specifically, the plaintiff must allege a conspiracy to, for purpose of depriving either directly or indirectly any person or class of persons of equal protection of the laws or of equal privileges, immunities under the laws, and an act furtherance of the conspiracy. Four, whereby a person is either injured in his person or property or deprived of any rights or privileges of the citizens of the United States. The first element requires of the conspiracy that are based on fact, not on mere upon the plaintiff's own suspicion and speculation. To satisfy the second element, mere conclusionary allegations of deprivations of constitutional rights are insufficient to the state. As Your Honor articulated in his opinion denying the plaintiff's motion to expedite discovery, the plaintiff conspiracy claims are bald and vague assertions that other individuals are part of a conspiracy to defame Jakes, Exhibit S. Woo! So what Blackburn has done is quote the judge in the last video that we did regarding the denial of expedited discovery. Again, make sure you all check out the playlist. As you know, we've been covering this case and we'll be going over all the legal documents in this case. And anyway, let's get back to it because this we're almost finished with reading this. Defendant is entitled to attorney fees. Okay, so under 8340.18 of Pennsylvania's anti-SLAPP statute, the prevailing defendant is entitled to recover attorney fees, court costs, and litigation expenses. This provision reflects the legislative intent to deter baseless lawsuits designed to suppress constitutional protected free speech. In this case, the defendant has demonstrated that the plaintiff's claims are meritless and that litigation was initiated in bad faith. Purpose of fees shifting. The fee shifting mechanism ensures that individuals exercising their First Amendment rights are not financially burdened with retaliatory litigation. The Pennsylvania General Assembly explicitly incorporated this provision to prevent powerful figures or institutions from using the courts to silence dissent. Defendants qualifications for recovery. Defendants satisfied the statutory criteria for recovery of fees and costs because one, plaintiff's claims arise from defendants' protected public expression as defined under 8340.13 section 2. Plaintiff has failed to establish prima facie case for defamation per se or civil conspiracy as detailed in the preceding sections. And three, defendant is entitled to judgment as a matter of law, rendering plaintiff's lawsuit baseless and retaliatory. Public policy goals. Awarding attorney fees in this case aligns with the anti-SLAPP statutes overreaching goals of deterring frivolous and oppressive litigation. Such lawsuits undermine free speech and place undue financial burdens on individuals exercising their rights to speak on matters of public concern. Discouraging retaliatory litigation. Plaintiffs attempt to use the judicial system to silence defendant exemplifies the type of retaliatory litigation the anti-SLAPP statute was designed to present. By awarding fees and costs, this court can reinforce the statute's intent and send a clear message that meritless claims aimed at suppressing public discord will not be tolerated. By granting the defendant's request for attorney fees, costs, the court will uphold the anti-SLAPP statute purpose, protect constitutionally protected speech, and deter similar abuses of the judicial system in the future. The defendant respectfully requests an award of these fees to deter future misuse of the judicial system. Request for leave to file cross complaint. Defendant Duane Youngblood respectfully seeks leave from this court to file a cross complaint against plaintiff T.D. Jakes and son Jermaine Jakes for the social media threats sent by Jermaine Jakes on November 3rd, 2024. Exhibit 1 and Exhibit I and Exhibit T. The threat, which stated, quote, "You might be in dangerous territory, Duane. Just be careful," end quote, was sent from Texas and received by the defendant in Pennsylvania. This cross complaint would assert the strongest available causes of action under the laws of both jurisdictions as outlined. Causes of action in Texas, jurisdiction where the message was sent. Intentional infliction of emotional distress, IIED, legal standard under Texas law. IIED claims required proof of conduct that is so extreme and outrageous that it extends all possible bounds of decency in civil society. Additionally, the defendant must have acted intentionally or recklessly, and the plaintiff must have suffered severe emotional distress as a result. Application: the threatening message sent by Jermaine Jakes was extreme and outrageous, particularly given the existing power dynamics and the timing of the message shortly after the defendant's public interview exposing systematic abuse. The threat exacerbated defendant's PTSD as documented in his therapist's report and caused significant emotional distress. Harassment by communication, legal standard. Texas Penal Code 42.07 prohibits electronic communications intended to harass, annoy, alarm, or embarrass another person. While this is primarily a criminal statute, it can be provided it can it can provide the basis for related civil claims where emotional harm is demonstrated. Application: the threatening message, coupled with the context of the intimidation, may be actionable as harassment under Texas law. Causes for action in Pennsylvania jurisdiction where the message was received. Intentional infliction of emotional distress, IIED, legal standard. Pennsylvania recognized IIED claims when conduct is extreme or outrageous and intentional or recklessly cause severe emotional distress. Severe emotional distress must be supported by competent medical advice. Application: the threat received in Pennsylvania has directly impacted the defendant's mental health, causing hypervigilance, attacks, and a prevalence of fear for his safety. These effects are well documented in the therapist's report and meet the threshold of IIED. Harassment by communication, legal standard. Harassment occurs when communication is made with the intent to harm, alarm, or annoy the recipient. While primarily a criminal statute, it supports civil claims where the plaintiff can demonstrate harm resulting from the harassment. Application: the threatening nature of the message constitutes harassment primarily as it was made with the intent to intimidate the defendant following his public disclosures. Civil conspiracy, legal standard. Civil conspiracy in Pennsylvania require proof of an agreement between two or more parties to commit an unlawful act or to use unlawful means to achieve a lawful goal, along with the overt acts in furtherance of conspiracy. Application: if evidence suggests that T.D. Jakes and Jermaine Jakes coordinated to threat threat to silence defendant, a claim for civil conspiracy may be sustained, particularly if linked to retaliatory motives related to the defendant's public statement. Defendant seeks to leave to pursue compensatory damages for emotional and psychological harm caused by the threat, punitive damages for malicious and retaliatory nature of conduct, and attorney fees and costs associated with the cross complaint. Defendant respectfully requests that this court grant the leave to file cross complaint against TD Jakes and Jermaine Jakes for their role in social media threats and resulting harm suffered by the defendant. By addressing these retaliatory conduct, the court will uphold the principles of justice and protect the defendant's right to speak truthfully without intimidation. Conclusion: plaintiff's claims represent a clear and troubling attempt to misuse the judicial process to silence protected free speech and suppress public dialogue on the matter of the profound societal importance. The defendant's statements made on a platform dedicated to fostering awareness and reform contribute to the critical conversation about systematic abuse, institutional accountability, and long-term impact of misconduct within religious organizations. These statements are indisputably protected by under Pennsylvania anti-SLAPP statute and First Amendment. The plaintiff has failed to meet the legal standards required to sustain claims of defamation per se and civil conspiracy. The lack of evidence demonstrating falsity, malice, and any actionable harm renders the plaintiff's claim legally and factually insufficient. Furthermore, the plaintiff's reliance on speculative assertions underscore the retaliatory nature of the litigation, which serves only to chill free speech and burden the judicial system. The Pennsylvania anti-SLAPP statute is a critical safeguard against precisely this type of abuse, ensuring that individuals can engage in public advocacy without fear of financial ruin or proactive legal battles. By dismissing this lawsuit with prejudice, which means they can't bring it up again, the court will uphold the statute's legislative intent, protect constitutionally guaranteed freedoms, and send a strong message that meritless claims designed to intimidate and silence will not be tolerated. Defendant respectfully requests that this court one, dismiss plaintiff's complaint with prejudice; two, award defendant attorney fees, court costs, and litigation expenses according to 42 whatever. Three, grant defendant leave to file a cross complaint against Jermaine Jakes and plaintiff. And four, grant any further relief this court deems as just and proper. Woo! Excuse me. Okay, everybody, that was a lot. That was a lot. So, anyway,
writing lines to lift his name, no need I'm writing lines to lift his name. My spirit fed, his word is spread. My spirit fed, his word is spread. Pen to paper, truths I scribe, the soulful vibe. Pen to paper, truths I scribe, the soulful vibe. The Most High, that's amplified. To glorify the Most High, that's amplified. I am spreading the faith, for every tear he's ever near. For every tear he's ever near. Wise rise on Sunday morn. His wise rise on Sunday morn. His each melody a testimony, hearts reborn. A testimony, hearts reborn. In every verse a whispered prayer beyond compare, to lift the hearts of those in dark despair. We testify